The air in the Supreme Court chamber was thick with anticipation. The marble columns rose majestically, their stillness echoing the tense silence in the room. The only sounds were the occasional shuffle of paper and the hushed whispers from the gallery. All eyes were fixed on the bench, and then on the woman standing alone at the podium. Pam Bondi, former Florida Attorney General, took a deep breath and adjusted the sleeve of her navy suit. Calm, composed, prepared. She had argued before this court 3 times before, but today was different. Today, she wasn't just facing 9 justices, she was facing the embodiment of a legal culture war, represented by the sharp, calculating figure of Justice Amy Coney Barrett. Barrett, the youngest on the bench but undeniably formidable, leaned forward slightly. Her robe shifted with the movement, her gaze narrowing on Bondi. The tension in the room was palpable. "Miss Bondi," Barrett began, her voice cutting through the silence with surgical precision, "you claim the constitutional structure prohibits the Department of Labor's rule here, but I'm struggling to find a controlling precedent to support your interpretation. Perhaps I've missed something during my years on the bench." A faint ripple of laughter echoed from the gallery. Bondi could feel the challenge in the air, the subtle power play, the quiet dismissal. Barrett's almost imperceptible smirk was a calculated move to destabilize. Bondi knew this was the moment she had to respond with strength. For a fleeting second, Bondi's hands gripped the podium harder, her knuckles whitening. 30 seconds left, 30 seconds to choose her path. Retreat? Respond weakly? She had a better idea. Bondi lifted her chin, her eyes locking with Barrett's, and her voice came out firm and unwavering. "Justice Barrett," she began, her tone level but with a quiet force, "I appreciate your challenge. Let me direct the court's attention to 3 cases that provide a firm doctrinal foundation for our position." She didn't glance at her notes. She didn't hesitate. She launched straight into her response. First, Whitman v. American Trucking Assiness, 531 U.S. 457, 2001. In that case, the court explicitly held that the delegation of legislative authority to agencies must be bounded by an intelligible principle. Justice Scalia's majority opinion stated, "Agencies do not have unfettered discretion where Congress has clearly demarcated boundaries." Justice Alito raised an eyebrow, acknowledging her point with a slight nod. The weight of her words hung in the air. Second, Bondi continued, FDA v. Brown and Williamson Tobacco Corporation, 529 U.S. 120, 2000. The court found that agencies may not assume regulatory authority over matters Congress has not clearly assigned. And third, she turned toward Barrett, her gaze steady. Collins v. Yellen, 141 S. CT 1761, 2021. Justice Barrett, in your own concurrence, you wrote, "When interpreting a statute, courts must be careful not to extend federal agency power beyond the boundaries clearly set by Congress." Your own words, Justice Barrett. That principle lies at the heart of our argument today. The room went completely still. The air seemed to hold its breath. Several journalists raised their pens, the click of their pens louder than usual. Chief Justice Roberts raised an eyebrow, exchanging a brief glance with Justice Gorsuch. Barrett's smile, that trademark, controlled smile, vanished. The tension between the two was palpable. For a moment, no one spoke. The atmosphere in the chamber felt frozen, as though the weight of Bondi's words had suspended time itself. Finally, Barrett shifted slightly in her chair, breaking the silence with a subtle movement. Her gaze didn't leave Bondi, but her tone softened, the challenge still lingering in her voice. "Miss Bondi," she said, her voice calm but edged with precision, "you cite these precedents, but how do you reconcile your interpretation with the need for regulatory flexibility in today's economy? What if Congress has deliberately left certain matters to agency discretion? How do you address that?" Bondi felt the question's weight. She had anticipated it. Her pulse quickened, but her outward demeanor remained unflinching. This wasn't new. Barrett's questioning was designed to unsettle, to test her resolve. But Bondi was ready. "I understand your concern, Justice Barrett," Bondi replied, her voice steady. "But my argument isn't about stifling agency discretion. It's about ensuring that discretion is exercised within the bounds of what Congress has authorized. If we allow agencies to operate beyond those boundaries, we risk a violation of the separation of powers. The executive branch is not meant to legislate. The words resonated, echoing in the chamber. Barrett's eyes narrowed slightly, and for a brief moment, she seemed to reconsider her stance. The justices exchanged glances, communicating in their silent way. "I appreciate your response," Barrett said, her voice softening just a touch, but still holding its firm edge. "But the court has often deferred to agencies in areas where Congress has been silent or ambiguous. Are you suggesting we abandon that precedent?" Bondi took a moment, her mind racing, but her response came without hesitation. "I'm not advocating for a complete departure from precedent, Justice Barrett," Bondi said. "What I'm proposing is that we adhere to the constitutional limits established by Congress. We cannot afford to allow agency power to grow unchecked, for doing so would erode the very structure of our democracy." Silence once again fell over the chamber. The weight of her words hung in the air like a heavy fog. Barrett didn't respond immediately. She leaned back in her chair, her fingers steepled in front of her lips, absorbing the impact of Bondi's argument. The room waited. Finally, Barrett spoke, her voice soft but still sharp. "Miss Bondi, your argument is compelling. But the court must consider not only the constitutional limits but also the practicalities of governance. Can Congress truly address every nuance of every regulatory matter, or is it necessary for agencies to step in where Congress leaves gaps?" Bondi didn't flinch. She knew this was the crux of the issue, where theory met reality. She paused for a moment, then responded with the same deliberate clarity. "Justice Barrett," she said, her voice unwavering, "the Constitution provides a clear framework. Agency power must be derived from Congress, not from silence or ambiguity. If we allow agencies to expand beyond their prescribed limits, we risk undermining the democratic structure that has served this nation for over 2 centuries. Chief Justice Roberts leaned forward, considering the weight of Bondi's words. The other justices were lost in thought, some nodding in agreement, others leaning back, contemplating the broader implications. Barrett's gaze didn't leave Bondi. After a long pause, she spoke again, quieter now but no less authoritative. "I hear you, Miss Bondi. Your argument is strong. It will give us much to consider as we deliberate." And just like that, the moment of confrontation passed. The courtroom, which had been thick with tension, slowly began to exhale. Bondi exhaled as well, her posture straight, her demeanor resolute. She had made her case. The outcome was still uncertain, but she had held her ground against one of the court's most formidable voices. Bondi stepped away, having defended the Constitution and the balance of American democracy. In that moment, she knew, no matter the outcome, she had already won.